Members of the court, you are further advised that the accused has an absolute right to remain silent. The court will not draw any adverse inferences from the fact that the accused did not take a stand and testify as a witness. The fact that he has not testified must not be considered an admission of guilt, nor may it be used against the accused in any other way.
This presentation is concerned with the right of military service members not to incriminate themselves when they are subjects of a criminal investigation. This right to remain silent is a fundamental part of the American system of criminal justice, whether administered by military or civilian authorities. It's a right which exists not only at trial, but throughout the course of a criminal investigation. As a participant in the legal process, you should be aware of the scope of the right to remain silent before trial, so you can avoid basic errors in advising service members as to their rights. In addition, you would be able to recognize those situations where it may be advisable to seek expert assistance. It's important, first of all, to understand the sources in military law of the right to remain silent. In June of 1966, Airman Third Class Michael L. Tempia, United States Air Force, was tried by General Court-Martial and was convicted of taking indecent liberties with females under the age of 16. Part of the evidence introduced against the accused was his written confession. Upon Tempia's appeal of his conviction, the Court of Military Appeals held that the serviceman's right against self-incrimination and his right to counsel require that before law enforcement personnel may question a suspect who is in their custody, they must first advise him of certain rights. Any statement obtained without such advice first being given is inadmissible in trial by court-martial. The court's holding in the Tempia case was based upon the decision of the United States Supreme Court in the case of Miranda versus Arizona, which was in turn based upon the Fifth and Sixth Amendments of the Constitution. As a result of this holding, Tempia's conviction was reversed. Now, there are certain warnings or advice which are required as a result of the decision in the Tempia case. Had Tempia been given these warnings prior to being interrogated, his confession would have been admissible in evidence at his trial. The first warning is that the suspect has the right to remain silent. Second, that any statement he does make can and will be used against him in trial by court-martial. Third, that he has the right to obtain and consult with a lawyer, or if he wishes to have superior military authority, appoint a military lawyer to act as his counsel without cost. And fourth, that he has the right to have his lawyer, civilian or military, present during the interview. The second source in military law is Article 31B of the Uniform Code of Military Justice. The rights contained in this article are statutory rights which have existed in military law for over 20 years and are generally broader than the rights provided by the Tempia case. Article 31B requires that military personnel engaged in criminal investigation must advise a suspect of certain rights before asking him to provide any statement. First, a statement as to the offense or offenses which the suspect is believed to have committed. Second, that the suspect need make no statement. And third, that any statement he does make may be used against him in trial by court-martial. As you can see, this advice is very similar to the advice required by the Tempia case. However, there are some important differences. Advice under Article 31B is required in a variety of situations, whereas the Tempia case only applies when a suspect is in the custody of law enforcement officials. Now, the term custody includes any situation in which a suspect has been significantly deprived of his freedom of action. For example, when a suspect has been summoned to an investigator's office for questioning or appears at captain's mast or office hours, he is considered to be in custody. In contrast to this, the advice required by Article 31B must also be given even when the suspect is not in custody. The Tempe advice only applies to requests for oral or written statements. Article 31B, on the other hand, applies not only to these requests, but also to requests to perform incriminating acts, including requests to produce body fluids. Now, generally, the proper procedure is to combine the two sets of warnings in all cases where either set would be separately required. The full advice then consists of 5 parts plus a 6th part strongly recommended by a number of court decisions. This is the suspect's right to terminate the interview at any time, also be explained to him. In the case of a larceny suspect who is being questioned in a custodial situation, you would use the following combined Article 31B and Tempia advice. First, you are suspected of having committed the offense of larceny. Second, you have the right to remain silent. Third, any statement you do make can and will be used against you in trial by court-martial. Fourth, you have the right to consult with and to obtain a lawyer, either a civilian lawyer retained by you at your own expense, or if you wish, Navy or Marine Corps authority will appoint a military lawyer to act as your counsel without cost. Fifth, you have the right to have your retained civilian lawyer or appointed military lawyer present during this interview. And sixth, you have the right to terminate this interview at any time and for any reason. Following these warnings, it must be determined whether or not the suspect understands his rights and whether he wishes either to consult a lawyer at that time or to terminate the interview. These questions must be specifically asked of him, and he must specifically state that he wishes to waive each and every one of the explained rights. Such a waiver, in order to be legally effective, must be intelligent, knowing, voluntary, and unequivocal. Only when this entire process has been completed can a statement legally be taken from the suspect. Your language should adhere very closely to the example I gave. Any substantial deviation may result in a legally defective warning. However, when you advise the suspect of the offense, considerable flexibility is allowed, and you need not cite any statute or article of the UCMJ. A simple statement of the nature of the suspected misconduct will be sufficient. It might appear that the requirement of Article 31B and the United States versus Tempia place a very heavy burden on law enforcement officials as they attempt to carry out their assigned duties. Now, this is not really the case. In a vast majority of those situations which are routinely faced by law enforcement officers, no warning or advice of any kind is required. For example, when a law enforcement officer is simply attempting to maintain order, conduct a routine apprehension, or conduct a simple search, no advice of any kind is required. The reason for this is that the officer is not requesting any statement or incriminating act. In addition to being unnecessary in situations such as these, it can sometimes be impractical or even dangerous to take the time necessary to advise the suspect of his rights. Let's look at a situation where 2 Shore Patrol officers are approaching a suspect with the intention of apprehending him for disturbing the peace.
Hey, baby, what's happening in there?
Barnes, you're under military apprehension.
Screw you, pig. You can't arrest me. I haven't done anything.
Turn around, put your hands on your head, get on your
Hell,
knees.
I will. How about my lawyer? How about my rights? I know my rights.
This is a proper lawful apprehension. No advice as to rights is required. Even if contraband is found on the accused, or if the Shore Patrol wanted to conduct a complete search incident to this lawful apprehension, there still is no requirement to advise the suspect of his rights under either Article 31B or Tempia. Advice as to his rights is only required if the petty officers had desired to question the suspect. In addition to being unnecessary or dangerous, there are sometimes situations in which it would be, in legal terms, a useless act to advise a suspect of his rights. Such a situation exists when the suspect is intoxicated as a result of the prior use of alcohol or drugs, when he has been heavily sedated, when he is in shock or great pain, or when he is unable to understand the English language. If a suspect is advised of his right in one of these situations, a court may later hold that he did not have the mental capacity either to understand or to give up his rights. Therefore, nothing he may have said will be admissible in evidence. Remember, a suspect's waiver of his rights, in order to be legally effective, must be intelligent, knowing, voluntary, and unequivocal. Here is an example of such a situation. Shore Patrolman Smith is approaching a suspect to apprehend him for the use of an illegal drug.
Blair, you're under military apprehension.
Far out, man. What a trip. You guys for real?
Put your hands on your head and get on your knees.
What are you guys doing to him? Hey, he's not doing anything. Hey, I'm really sorry, man. Oh, wow. Hey, take it easy. You didn't doing anything. Fine, using that? Hey, wow.
Essence of dragnet, man. What a Dick Tracy trick. Let's go, Blair.
It would be a useless act to advise the suspect of any rights in his condition. Even if his rights were given and waived, any statements made by the suspect would undoubtedly be held inadmissible at a court-martial. In cases such as this, further investigation should appropriately be conducted only when the accused is once again competent to understand and acknowledge his rights. Petty Officer Smith properly handled the situation. He limited his activities to conducting an apprehension and search incident to that apprehension. No warnings of any sort were required in order to accomplish this. Warnings would have been required if Smith had intended to question the suspect about either the contents of the vial or his condition. Considering the condition of the suspect, such questioning would clearly have been improper. Even when a suspect is in complete control of his faculties, he may sometimes become confused when he has been unnecessarily advised of his rights, in a situation where it was neither necessary nor appropriate to do so. Let's look at a situation that illustrates how this can happen. Petty Officer Gonzalez is about to apprehend a suspect for desertion.
Once, on the military apprehension, turn around and straddle the car. In your left hand. In your right hand. You're suspected of the offense of desertion. You have the right to remain silent. Any statement you do make can and will be used as evidence against you in a trial by court-martial. You have the right to consult with and obtain a lawyer, either a civilian lawyer retained by you at your own expense, or, if you wish, the Navy will appoint a military lawyer to act as your counsel without cost to you. You have the right to have your retained civilian lawyer or appointed military lawyer present during this interview. You understand this, Schwartz?
Uh-huh. I want a lawyer.
Well, you're not going to need a lawyer, Schwartz. I'm not going to question you.
Following his apprehension, Schwartz has been taken to Shore Patrol headquarters, where he is being interviewed by Mr. Taylor of the Naval Investigative Service Office.
Schwartz, you have the following rights. You are suspected of having committed the following offense: violation of the UCMJ Article 85, desertion. You have the right to remain silent. Any statement you do make may be used as evidence against you in a trial by court-martial. You have the right to consult with a lawyer prior to any questioning. This lawyer may be a civilian lawyer retained by you at your own expense, or if you wish, the Navy will appoint a military lawyer to act as your counsel without cost to you. You have the right to have such retained lawyer present during this interview, and you may have the right to terminate this interview at any time and for any reason. Do you understand your rights?
Yeah, I suppose so.
Do you want to see a lawyer or terminate this interview?
No, I guess not.
Do you want to talk about it?
Yeah, I suppose so.
Swartz proceeds to confess to the desertion and is subsequently brought before a court-martial. The government's case is primarily based on his confession to the offense of desertion. The most that can be proved without his confession is the offense of unauthorized absence.
Swartz, did you have your rights read to you?
Yes, sir, twice.
By whom?
By Shore Patrol and NISO.
What was your response the first time your rights were read to you?
I said I wanted a lawyer.
What did the Shore Patrol say when you requested a lawyer?
He said I didn't need one.
Did he read you that you had a right to have a lawyer present during the interview?
Yes, sir.
Did the Shore Patrol actually get you a lawyer?
No, sir. When he read me my rights that I could have a lawyer, I kept asking for one, but he just ignored me.
Did you ever see a lawyer prior to the time that I was appointed to represent you at this court-martial?
No, sir.
Who read you your rights the second time?
Mr. Taylor of NISO.
Did you again request a lawyer?
No, sir.
Why not?
I didn't think I could get one, since Shore Patrol wouldn't give me one.
Did you understand that during this second interview you had a right to have a lawyer present?
No, sir.
Why not?
Well, when I first asked Shore Patrol for one, and they said I didn't need one and couldn't have one, I didn't think Mr. Taylor would give me one, even if I asked him for one.
Did Mr. Taylor explain to you that you had a right to have a lawyer present during this second interview?
He said something about it, but I was pretty confused. All I knew is that it wouldn't do any good to ask him.
Did you tell Mr. what the Shore Patrol had done?
No, sir.
Your Honor, at this time, I would object to the introduction of the proffered confession into evidence. It is obvious that the accused was not actually made aware of his right to have a lawyer present during the interview with Mr. Taylor of NIS. I am sure that you can see the confusion caused by the initial warning of rights by the Shore Patrol, the accused's subsequent request for counsel, and the denial of this request by the Shore Patrol. This entire chain of events frustrates the intent of the 31B and Tempia warnings. The accused could not intelligently and knowingly waive his rights to counsel when he was confused as to what those rights were. We acknowledge that Mr. Taylor did nothing improper here. However, someone should have straightened out the confusion caused by the Shore Patrol. Again, Your Honor, we would object to the admission of this confession into evidence.
Trial counsel, do you wish to offer any further evidence for me to consider before I rule?
No, sir, Your Honor.
In view of the somewhat confused chain of events in this case, I'm inclined to agree with the defense that the accused did not really understand his rights. Therefore, I will sustain the defense objection, and the alleged confession will not be admitted into evidence.
The result of the judge's ruling in this case will probably be the acquittal of the accused of the charge of desertion. It's important to note in this case that the problem of the accused's possible misunderstanding of his rights would never have arisen had the Shore Patrolman simply apprehended the suspect rather than attempting to advise him of his rights. There was no need to do so. Within the military legal system, advice as to rights should ordinarily be given only by those law enforcement officials who have an actual need or duty to question the suspect. This includes NIS special agents, base security investigators, Article 32 investigating officers, and other individuals who have assigned duties which are primarily investigative in nature. You may have also noted that the suspect's waiver of his rights was not unequivocal. This should have prompted the NIS investigator to inquire further as to whether the suspect really understood his rights and wished to waive them. There are, of course, exceptions to the rule already discussed. As a participant in the legal process, you'll undoubtedly face situations from time to time in which you should advise the suspect of his rights. As you have already seen, a suspect should be fully advised of his rights in situations where the suspect is suspected of having committed an offense against the UCMJ, where he is in custody, and where he is going to be questioned or asked to do something which may tend to incriminate him. As previously mentioned, there still is often a requirement that advice be given under Article 31B alone, even when a suspect is not in custody. The protection of Article 31B is very broad. It's required whenever a subject is suspected of an offense against the UCMJ and is going to be requested to make a statement or do an act which may incriminate him. Let's look at some typical examples of circumstances which require advice under Article 31B. The duty master-at-arms has just learned that a young sailor has been seen with a number of marijuana cigarettes in his pocket. He's been trying to locate Carson in order to investigate the situation.
Carson, I want to talk to you.
Sure, what do you want?
Look, I'm going to level with you. I know you have in your shirt pocket there. I want you to hand over the joints.
The evidence which has just been obtained will not be admissible in any trial by court-martial. Carson's act of producing the illegal substance is considered an incriminating statement for purposes of Article 31B. Before the master-at-arms could legally have requested Carson to perform this incriminating act, he must first have advised Carson of his rights in accordance with Article 31B. In the alternative, it's possible that the master-at-arms could have conducted one of several types of lawful searches rather than requesting the suspect to incriminate himself. In the following scene, Petty Officer Davis, the duty master-at-arms, has just learned that one of the men on board may have stolen a cassette tape recorder from another sailor and hidden it in his locker. Petty Officer Davis has decided to ask for the suspect's consent to have his locker searched. Petty Officer Clark is accompanying him to act as a witness.
Benson, I want to search your locker. I have reason to believe you have stolen property hidden in there. Now, you have the right to refuse me to make any search, but I'm asking you for your permission. Will you let me search your locker?
Well, sure. Go ahead. I don't care.
Well, where is your locker?
It's the one right here.
This search, based upon the consent of the suspect, is perfectly legal, and any evidence found would ordinarily be admissible in any trial by court-martial. In this particular case, however, Petty Officer Davis has made a crucial mistake which has seriously tainted the search. The action of Benson in pointing out which locker belonged to him is considered an incriminating statement for the purposes of Article 31B. Before a suspect can be legally requested to perform such an act, he must first be warned of his rights under Article 31B. In this particular case, the government would not be able to use as evidence against Benson any reference to the fact that the tape recorder was found in his locker, nor the admission by him that the locker in question was assigned to him. Petty Officer Davis had two choices. He could have warned the suspect in accordance with Article 31B before questioning him, or he could have determined in advance from some independent source which locker belonged to the suspect. Let's look at a situation where the Shore Patrol has just apprehended Petty Officer Costello and taken him to the base dispensary.
Sir, I've got a man outside apprehended near the main gate. He's driving a government vehicle and weaving all over the road. I really think he's drunk. I'd like you to take a blood sample from him.
Sure, send him on in.
Costello, get in here.
Shore Patrolman told me how you happened to get picked up. I want you to sit down over there. I'm going to take a blood sample from you. I'd have to say you look pretty drunk to me.
The blood sample subsequently taken by the medical officer indicates an alcohol level high enough to provide strong evidence of intoxication. However, no evidence concerning this test and its results will be allowed to be introduced at any trial of Petty Officer Costello. The giving of a blood sample is regarded in military law as an incriminating statement. Before a sample can be requested or taken by a member of the armed forces, the suspect must be advised of his rights under Article 31B. It would have been proper for the doctor to observe and note the external physical condition of the suspect. For example, he could have noted the odor of his breath, the color of his complexion, the condition of his eyes, and the manner in which he walked or moved his body. In the last three situations, only Article 31B advice is required. However, when Article 31B advice is given, it's also highly advisable to give the suspect full warning under both Article 31B and the United States versus Tempia. Here are examples of additional situations where advice under Article 31B must be given even though the suspect is not in custody. Requests for the production of personal records or writings, requests for handwriting examples, requests for voice prints, and requests for urine samples, saliva samples, and other samples of body fluids. In situations such as these, the advice to be given must be specifically tailored to meet the requirements of the situation. In the case of a request for a blood sample from a suspect, the requesting officer should state that the suspect has the right to refuse to provide any blood sample. There are several situations which might appear similar to those just described. Advice as to rights might therefore appear to be required. However, because of various technical legal reasons, no warning of any sort is necessary. Such situations include medical tests given for the purpose of actual medical treatment, fingerprinting, and requests that a suspect exhibit external characteristics of his body, such as his complexion, hair color, and foot size, as well as any scars, tattoos, and other identifying marks. Another problem which sometimes arises in the course of investigations results from a rule of law known as the fruit of the poisonous tree doctrine. This rule provides that a confession which results directly or indirectly from a previous illegal search or confession is inadmissible in trial by court-martial. Here we see Chief Collins observing a young sailor carrying a radio out of the exchange. Based upon his observations, Chief Collins suspects that he has stolen the radio.
Hold it, son. You're under apprehension. What do you think you're going to do with this radio?
Hey, I bought this radio.
Okay, let's see the sales slip.
Look, Chief, I'm sorry. I don't know what I was thinking. I'll take it back. I've never done anything like this before. It just seems so easy to pick it up and walk out with it. I feel terrible about it.
It's not that simple. You're going to have to come with me.
The chief turns the suspect over to his command, where he is interrogated by the discipline officer.
You're suspected of the offense of larceny. You have the right not to make any statement. Any statement you do make can and will be used against you in a trial by court-martial. You have the right to obtain and consult with a lawyer prior to making any statement. Either a civilian lawyer retained by you at your own expense, or, if you wish, naval authorities will appoint a military lawyer to represent you at no cost to you. You have the right to have your lawyer, either civilian or military, present during this interview. You have the right to terminate this interview at any time. Do you understand these rights?
Yes, sir.
Well, if you do, I want you to sign this form, each of these rights on this form. Now, do you want to talk to a lawyer or terminate this interview?
No, sir.
Do you want to make any statement?
Yes, sir.
The confession which the suspect is about to make will not be admissible in evidence at any trial by court-martial. The confession is regarded in legal terms as being the direct result of the prior illegally obtained admissions to Chief Collins. Since the chief gave him no warnings, neither the admissions made by the suspect to the chief nor the later confession can legally be used as evidence. However, there is a way in which the discipline officer could have legally obtained a confession had he known about the mistaken actions of Chief Collins. The discipline officer under these circumstances could have given what is known as a modified warning. In other words, he could have advised the suspect of the illegality of the chief's actions and the fact that he need make no further statement merely because he had, in effect, already let the cat out of the bag. Let's see the same situation using the correct procedure.
You are suspected of the offense of larceny. You have the right not to make any statement. Any statement you do make can and will be used against you in a trial by court-martial. I am aware that you have made a previous statement about this incident to Chief Collins, who brought you in here. I want to advise you that that statement was illegally obtained from you. Because it was illegally obtained, it cannot be used against you in any criminal trial. You should not feel that you need to make any statement to me just because you've already made a statement to the chief. I want it to be absolutely clear to you that you have the right at this time to refuse to make any statement about this matter. Do you understand this?
Yes, sir.
The discipline officer will, of course, now be required to give the suspect the rest of the usual advice, informing him of his right to counsel and his right to terminate the interview at any time. He will also have to determine, as usual, whether the suspect wishes to waive his rights. If the suspect does choose to waive his rights and make a statement, the statement can be used as evidence at a subsequent trial. The same procedure of giving a modified warning can also be used in the case where a suspect is interrogated following an illegal search. There is no absolute guarantee that even a confession which is obtained following such a modified warning will be admissible at a later trial. It is obviously preferable that no mistake be made in the first instance. Proper advice to a suspect as to his rights is the only true guarantee of admissibility. Another problem which sometimes arises in interrogation situations revolves around the issue of voluntariness. Here we see Lieutenant Brown, the preliminary investigating officer, is interrogating a suspect concerning an alleged manslaughter violation.
Adams, you are suspected of having committed the offense of manslaughter, a violation of Article 119 of the UCMJ. You have the following rights. You have the right to remain silent. Any statement you do make may be used as evidence against you in trial by court-martial. You have the right to consult with a lawyer prior to any questioning. This lawyer may be a civilian lawyer retained by you at your own expense, or, if you wish, the Navy will appoint a military lawyer to act as your counsel without cost to you. You have the right to have such retained civilian lawyer or appointed military lawyer present during this interview. You have the right to terminate this interview at any time and for any reason. Do you understand your rights?
Yes, ma'am.
Would you like to waive your rights and make a statement?
I don't know. I'd like to talk about it, but I just don't know.
Listen, Adams, let's just talk about it confidentially, off the record. You'll feel better.
You mean just between you and I?
Nothing you say will leave this room.
Well, I guess I'll tell you. I have to tell somebody.
The suspect was properly advised as to his rights. However, any statement he may make will be inadmissible at any trial by court-martial. A statement made by a suspect is only admissible if it is a truly voluntary statement made with a full understanding of his rights. The suspect was the subject of unlawful inducement by the investigating officer. A statement is not voluntary if it is induced by a promise of confidentiality. Similarly, if a suspect is promised any benefit from making a statement, if he's threatened, bribed, coerced, harassed, or otherwise unlawfully influenced to give up his right to silence, nothing he says will later be admissible as evidence against him. This situation illustrates several common additional problems which may arise during the course of an investigation. Lieutenant Johnson of the Naval Station Police is questioning a witness to an alleged larceny by Seaman Recruit Jones. At the beginning of the interview, the witness is not a suspect to the larceny.
Wing, did you see Jones actually take the tape cassette from the Navy Exchange?
Yes, sir. I was right next to him.
Were you shopping in the tape department?
Well, you see, me and Jones went into the Exchange together to get this far-out tape. When we found it, we noticed we didn't have enough money to pay for it. So I told Jones to put it in his pocket while I was checking to see if the coast was clear.
Hold it, Wing. Let me advise you that you are now suspected of an offense under the UCMJ, Article 121, larceny. You have the following rights.
You don't have to read me those things. I already know all about my rights.
Just bear with me and let me read these to you. You have the right to remain silent. Any statement you do make may be used as evidence against you in trial by court-martial. You have the right to consult with a lawyer prior to any questioning. This lawyer may be a civilian lawyer retained by you at your own expense, or if you wish, the Navy will appoint a military lawyer to act as your counsel without cost to you. You have the right to have such retained civilian lawyer or appointed military lawyer present during this interview. You have the right to terminate this interview at any time and for any reason. Do you understand these rights?
Yes, sir. What a bummer.
Are you willing to waive these rights and make a statement to me?
Yes, sir.
Do you wish to talk to a lawyer or to terminate this interview?
No, sir.
Well, then, would you tell me what happened when Jones took the tape?
Well, we started trucking out of the store until this plainclothes dude stopped us out back of the Exchange.
What happened then?
Well, when he was talking to Jones, I bumped him on the head and we split.
Hold it, Wing. This is getting to be a little more complicated now. You are now suspected of the offense of assault, a violation of Article 128 of the UCMJ. You have the following rights.
As you've seen, 31B and Tempia rights must be given to an individual when he's a suspect and is going to be asked to incriminate himself. The problem lies in determining when a subject becomes a suspect. The courts have held that when an individual is either actually suspected or when the investigator should have considered him to be a suspect, he must be advised of his rights. Wing became a suspect in this case after he made the statement that he was involved in the larceny. Lieutenant Johnson very properly advised him of his rights before resuming questioning. The next problem which arose was the suspect's insistence that he already knew his rights. Even though a suspect feels he knows his rights, it's still essential that the full warnings be given to him, even over his interruption or objection. When Wing made further incriminating statements which concerned conduct other than the alleged larceny, it became necessary that he again be advised of his rights, this time concerning the new alleged violation. Any time a new offense is suspected by an investigator, he should immediately advise the subject that he is now suspected of that additional offense. The actions of the investigator in this case may appear to be redundant and time-consuming. However, the procedures which he followed are the only way to ensure that any statements made by the suspect will be fully admissible at any trial which may later result. Now, we hope that this presentation has helped you to better understand the right of a suspect to remain silent. It's not intended to make you an expert on the numerous problems connected with this subject. However, the results of a failure to give proper warning when required can be far-reaching. As you've seen, any statements made without proper advice, as well as the results of any later interrogations or searches, are usually inadmissible in trial by court-martial. In addition, if new witnesses have been discovered through an illegally obtained statement, they will probably not be allowed to testify. But most serious of all, it is possible that illegal questioning may so taint the proceedings that an entire case against an accused must be dismissed. We hope that you're now more aware of some of these legal pitfalls. It's a fundamental principle of our judicial system that no person may be asked to provide any evidence against himself unless it's first clear that he is fully aware of his right against self-incrimination. You have also seen that advising military personnel of their rights is not something to be done indiscriminately, without regard to the question of whether the particular situation requires that this be done. Our system of justice can only operate properly if you, as an individual involved in the legal process, clearly understands the minimal legal principles required to carry out your assigned function in that process in a proper, effective, and lawful manner.